So the Substantive Decisions Act is your document that governs the power of attorney for personal care and the continuing power of attorney for property. It's a total different act than the one I just mentioned. And it also covers a whole bunch of other things. Guardianship for adults, anybody over the age of 18. It covers intestate. Intestate is the passing without a will. So if you pass with a will, you pass in state. If you pass without a will, you pass intestate. What happens if you pass without a will in the province of Ontario, technically speaking, the organization that's supposed to be told is the Office of the Public Guardian and Trustee. See the trustee? They're the ones that will then look at the law and decide what happens to your estate if you pass without a will. Now, a will can be a simple thing as I, John Smith, Wasaga Beach, on the 17th of October, year 2022, bequeathed everything to. It can be that simple. But if you pass with nothing, then you trigger that. What that then triggers is they still use the term, it's not, in the legal world they've come up with other verbiage, but probate. And a lot of people go, that's a nasty term. Because probate triggers taxes. In Ontario, it's called the EAT, the Estate Administration Tax. So if I'm not scaring you in any other way, I'll give you the quick math on the EAT. The math for the EAT is the following. The entire estate, regardless of whether you want to bequeath certain items to individuals, the entire estate has to be added up. Your clothing, your housing, your toys, your collectibles, your dog, your cat, your silverware, yada yada, all up to a value. And it has to be a fair market value, not a guesstimate. So from your resident's perspective, it has to be a proven value. And it can't be, well, we think it's worth 600. No, you're gonna have to go out and get an actual appraisal done. Car is the same thing. Boat, toys, they all have to be appraised. By the way, the estate's paying for the appraisal. But you can't deduct the appraisal. Total value of the estate. Most people today, I would suggest, doesn't take long to hit $1 million. Probably closer to 2 million. So let's just, for sake of purpose of example, again, the point for you to understand is intestate, and share this with your family, because there's a lot of young people, especially in my profession, who do not have a will. I find in my profession only about 10% have a will. The math is simple. Total value of the estate minus the value of a mortgage. Now, if you've got a shared residency, you only own 50% by law, or you can only take 50% of the mortgage off. And in the interest of being kind to you, you then can take $50,000. Deduct that from the total. So imagine that you've paid your mortgage off. Congratulations, well done, you worked so hard, excellent. So your only deduction is $50,000 from the $2 million. Now, the tax is $15 for every $1,000, which must be paid at time of filing before the court, before any action is supposed to take place on your estate, which includes your funeral arrangements. Burial versus cremation, flowers versus wax, whatever, because that's where the executor has the power to make those decisions. So what a lot of people don't realize is how much is involved in this by passing intestate. You leave a mess behind for people to sort out. Office of Public Guardian and Trustee, again, they should come in play. They're also the ones that will take over adult guardianship, if the closest thing we have to adult protection in Ontario. And they also define the rules for legally determining a person is incapable, mentally speaking, not physically. Excuse me. Power of attorney document for personal care, we often hear people say that it's the well-being. We don't have doesn't exist, okay? The attorney for health doesn't exist, okay? And the other one is a living will. We don't have such a thing in Ontario. But if you do your power of attorney for personal care properly, you can express your wishes in the event of certain incidents occurring. So it basically becomes a living will, if you would. But we have nothing such as a living will. Doesn't exist. Personal care is actually 6 categories. These are them. Now, you said, a lot of people ask, do I need a power of attorney for personal care? And the answer is you got to reflect upon yourself. Go look in the mirror and ask yourself quite simply. In the event that I have a health issue, what will happen to me if I don't have a personal care? Well, the healthcare system in Canada is such that they must do everything possible to help you. That may not be in line with your wishes, but they must do so because they have a legal responsibility, right? They being the medical professionals, they can be held accountable for not doing the proper actions. So you may be hooked up to that machine that keeps your heart working for months on end. That may not be your wish, but because you don't have a power of attorney for personal care, that could be the outcome. Do I need a power of attorney for personal care? So the list continues. I know if I don't have one, my health is going to be taken care of, according to the standards. However, the other items in here will not be. So technically, someone else is not speaking on my behalf. You think, what's nutrition got to do with it? Shelter. Well, you're going to live in your home until you pass, or you're going to live in a nursing home? Well, retirement home or long-term care facility. We don't have nursing homes anymore. Clothing, hygiene, safety. The way I suggest to people, the easiest way to reflect upon this is imagine you just came out of the shower and you're looking in the mirror. That's you. Everything about you as an individual. You. When you grab that towel, that mat that you're standing on, the room that you're standing in, and the dog that's coming over to say hello, that's property. That's everything else. But you as an entity, a standalone individual, that's personal care. So what works to your personal care at the end of the day? Those are the 6 categories. If you're comfortable that the healthcare system is taken care of, and you don't really worry about these, you don't need one for personal care. But if these are of concern to you, then you want to consider it. When it comes to shelter, there is also a possibility of someone else speaking for you. And that's called I'll get to that in a sec. That's called substitute decision maker, which I'll get into just a moment. What a lot of people don't understand with personal care, though, is it's event triggered. It is not continuous like property is. It's event triggered. And the individual who's involved in this, the grantor, it is expected they be part of the conversation. Even if the healthcare believes that they're not capable of providing part of the discussion and adding to it, they're still expected to make an effort. So if you've ever had the situation where, let's say, a family member, and you might have been appointed the attorney, and the doctor takes you down the hall to have that conversation, you shouldn't be going down the hall. You should be standing beside the individual, having that conversation, hoping that they can engage with you, and if they can't, at least you've tried. There's no secrets being kept here. We're talking about an individual here. Right? This is not a discussion that should be happening in the lobby of the hospital. It's the personal care of an individual. So they are expected to be a part of that conversation, even if they've been legally deemed incapable. But what happens with this particular one, which people do not realize, unless you've been legally deemed incapable, it is only event triggered. So you're going to go in the hospital today. Tomorrow you're in surgery, so you're under that medication, will not allow you to see clearly. When you come out of that medication and you're back, personal care, power of attorney personal care is in place. The attorney can make decisions during that period of time. As soon as you come back to reality, it is no longer in play. 2 years from now, you have to go in for a different surgery or something, scenario starts again. but it has not gone on for 2 years, which people use and abuse all the time. They also try to say, well, I'm the POA is what they always say. We both now know that it's the attorney for personal care. And because I am, I don't want my sister visiting mom. And I expect you, institution, to make sure that my sister doesn't see my mom. And here's her name. No. It happens all the time, folks. All the time. And it is illegal. Okay, the only person that cannot or can make the decision as to who is going to visit them is the grantor. So it would have to be mom that says, no, I don't want to see my daughter. But yet it happens all the time. And I see way too much of it. You can also not make end-of-life decisions. You can put in there that you want a narrative that says, make me comfortable. I don't want all this machinery and stuff. Let me go naturally. But you can't say, put a needle in my arm and speed it up. Because that is called the MAID. And that's a whole different, that's a federal law. A medically assisted death. That's a whole different set of rules. And that's a whole gamut of, because it's suicide. And suicide in the criminal code is illegal. Unless it's under MAID. So you can't put that in there. Well, you can, if you put it in, it's disregarded. There's no value in having it. Okay? This is the big thing on capacity. I won't go into that too much right now. But here's the Substitute Decisions Act. So what happens in the healthcare world? So when I'm saying healthcare, I'm thinking of a hospital environment and or health support. Okay? It's very, very important that you understand that. So you're not in a position that you're able to provide clarity of decision, or you don't understand the ramifications of not giving me a decision. So if you're not sure that, just remember the last time you went to the doctors and the doctors said, well, Claire, you've got this, and this is what we can do about it. If we do surgery, here's the issues related to surgery. If we give you medication, yada, yada, yada. Anybody ever experienced that with their doctor? To some degree, right? Anytime you've interacted with your doctor, they're actually doing what's called informed consent. They're telling you what the situation is, they're telling you what can be done, and the outcomes of that. And what they expect from you, what they're looking for is consent. Either you're going to say, yes, I'll go with the surgery, or I'll go with the medicine, or you do have a third option, by the way, and that's a second opinion, correct? You've always got a second opinion. The other thing they're going to look for, though, is if you say, nope, I don't want the surgery, nope, I don't want the medication, they go, but do you realize what will happen in the event that nothing takes place? And you go, yeah, I fully understand that, and then that's informed consent as well. What happens in the medical world, then, is they turn to the Substitute Decisions Act if you're in a position where you cannot provide that consent. First up is guardian, and that's court-ordered. So that's a person appointed by the courts. The second is your attorney. You're under your power attorney document. So that person that you as the grantor have appointed to represent you at a time when you cannot make decisions relative to your personal care, in particular health, the attorney is now they're going to turn to that person. So they're going to need to see the document, to see the person. Sometimes that's your spouse of 50 years. Other times, it's your child. It may be your friend. It may be your neighbor. It could be your lawyer, because some lawyers will allow themselves to be appointed. Why do you pick someone other than a spouse? Well, what people don't realize sometimes is some spouses, they're human. This is a tragic moment, potentially, in their life. They've spent 50 years with you, good or bad, but they've spent 50 years with you. They may have the wish to spend 51, but that may not be in line with your wishes. So there could be, you may realize that there may not be a clarity of decision based on what I want, because they disagree with what I want. You could also look at the fact that it puts additional stress on a very stressful situation. So by picking someone outside, shall I say, my inner circle, I can get clarity of mind because that's what I need. This is my health right now that needs decisions to be made. And I need clarity of mind to make those decisions. I don't need this to do the talking. I need this to do the talking. So at times you actually find that people will appoint someone other than their partner or immediate family, etc., as their attorney. So that when they turn in the medical world and say, who's the substitute decision maker, they will say SDM normally. They're going down this list. If you have nobody there, then they're going to go to the Consent Capacity Board. That's a government agency that could potentially make decisions on your behalf. Maybe you want a power attorney for personal care then. The next one is your spouse or partner. Notice again that the attorney trumps the spouse. Okay? They could be the same person, but the roles are different, right? Completely different roles. And then it starts working down. And last but not least, if the situation occurs, that they go to the public guardian trustee and they seek clarity from them. And that brings in legal teams and a whole long process. And that's the check and balance, if you would. And what happens in the medical world is if they find that the attorney's not making appropriate decisions for you, they can decide, and they have to follow certain protocols, but they can go down the list if the decisions, in their opinion, are not being made appropriate to your well-being and your health. Now, if you do a power attorney for personal care and you find a narrative in there that has clarity, what you've done is twofold. You've put your thoughts on paper, and now you're expressing them to the person who's supposed to speak when you can't. And it takes the burden off them, because if anybody challenges them, they just provide the document and say, here it is right here. It's not me interpreting what he thought. It's what he's told me, and there it is right there in black and white, supported by his signature. I'm just the courier. I'm the delivery guy. Don't shoot the messenger. Right? So when you get into those challenges and say, well, that's not what he said yesterday over coffee, and that's not what he told me a week ago. Well, no, but that's what he told me when he put this document. Those are conversations. It could be interpretations, misunderstanding, whatever. This is where the clarity is. And that's why it's so important that you take these documents and you make them your own. One way to do that, this is not the best. Now, I actually took this from a lawyer-produced document. That was a single paragraph. I massaged it a little. If you can read that in one breath, good luck. But anyway, that's just one example. It is not necessarily the best narrative, but it kind of covers everything. The one thing that be careful of is heroic measures. I think I took it out. Sometimes you'll see people say, I don't want any heroic measures, and the legal world goes, what's a heroic measure? Don't put it in your document. You're just trying to say, let me go. The heroic measures is meaningless. Nobody can define what a heroic measure is. Is it a good acting in the movie you watched last night? Or is it a football game? Who's the hero here? Right? So don't be using that verbiage. But that is one way to do it. If you take a narrative, something, I would make it a little better than that. I deliberately don't improve this because I don't want you taking it verbatim and saying, Martin said, no. But that gives you an idea of what to consider. Again, it takes the burden off the attorney because there's my narrative with clarity. It's kind of like a living will because this is my direction that I'd like to go in the event of. It's nothing illegal in the sense that I'm asking people to do things that they cannot legally do. And it's telling everybody that reads it what I want. I'm not so sure the clarity is there, but.
Yeah. Could you give us a couple of examples of some cases you've investigated where the adults have been abused by their children?
Oh, yeah.
Monetarily?
Oh, I see it all the time. One of my first ones, well, my first one that was big back in 2014 was a long-term care facility was reporting that they weren't being paid. Now, when you're in a long-term care facility, you're a resident, you're not a tenant. So you're not protected under the Landlord-Tenant Act. But when you're in long-term care, the only person who can kick you out of long-term care is yourself. Now, not everybody in long-term care is incapable mind. We all think that is what the case is. Anybody over the age of 18 can be in long-term care. All it means is they need 24/7 care. So there could be a 20-year-old in there, unfortunately quadriplegic, in a long-term care home. Does not mean that they don't have clarity of mind. It's a physical requirement. One big misunderstanding. The other is the fact that they're a resident. So what happens is, as a resident of a long-term care facility, you get 3 squares. It's a military term. It means you get 3 meals a day, okay, and you get a pillow. That's it. Okay? So toiletries is the resident's responsibility. Clothing is a resident's responsibility. Haircut, resident's responsibility. You want to get out of the place and go on an outing. Pay for the $5 for the bus trip. Well, what's $5? Well, when your pockets are empty, it's everything, right? You don't have it, you don't have it. So what happens in long-term care, if they're not paid, there's always an income coming in. Everybody has some form of income, whether it's old age security, because you're over the age of 65, whether it's CPP, which you can get at any age, but if it's relative to retirement, it's a 65 or higher, as long as you're paid into it. You may have an additional pension plan come into play. What happens is the room rent is set by the government annually, but they don't necessarily get to charge that. They have to look at your income. And the room is rated on your income, but they must deduct from your income personal care. It's called personal care. And right now it's $149. Back in 2014, it was $139. Now, when's the last time you went to Shoppers Drug Mart and bought toiletries, toothbrush, toothpaste, shampoo? Oh, by the way, you need to go to a different store to get clothes, but you only have $139 to do it.
A month.
A month. So if you're not paying the long-term care facility, that person's not getting that care. So what was happening with this individual was Mrs. Phillips, she's passed, was that it was reported that she wasn't getting that. The resident bill wasn't being paid, and it was in the thousands. And it was growing every month. And so when I did my investigation, I discovered that her daughter had taken $320,000 over 6 years. And every time the money would come into her bank account every month, the daughter took it. In fact, she came up here. She would go camping up here. But mom was never seen. The staff, I interviewed staff members to see how often family would visit. And she basically did what, unfortunately, is a very gross term in my opinion. It's called a curb dump, which means you drop the person off and you never come see them again. You know, Mother's Day, Easter, maybe 10 minutes at most. And if you don't know that they keep track of that, and I can get it through judicial order, and I got it, $310,000 in 6 years. She started out looking after her mom really good. And then she fell off the planet with her mom. And then when she needed money, she came back into the social network. And when I charged her at $87,000. And on second day of trial, she picked a jury trial. She pled guilty to $30,000. But what happened was Mrs. Phillips, public guardian trustee took control of her. So they took over management of her property. So the bleeding of her finances stopped. But that was unfortunately it. That was her own daughter. I've had Athol, you could read about in the paper, a reverend from Nova Scotia would come to Ontario to rip off seniors. He connected with a contractor. A guy called himself a contractor. He's a professional fraudster all his life. And they ripped off Athol. Ethel was very proud of the fact that her and her husband back in the 80s paid off their mortgage in 6 years, almost unheard of. And I was you think I'm the Grim Reaper here. I had to tell her that she had a mortgage on her house and that she had nothing left in her bank account. They cleaned out $70,000 cash. They put a $150,000 mortgage on her house. And yeah, that was a jury trial. That took 15 weeks of trial at the 2 different levels. The jury took less than 4 hours to convict them. Goodness. That took.
What type of time would they get for destroying a person's life?
Well, Alex got 6 years for Ethel. He was out in 2. The Reverend got 15 months. He was out in about 5 months. And Alex's wife got 9 months on weekends. And the way the system works on a weekend is if you're in the building by 4 o'clock and you leave by after 6 o'clock on Sunday, that counts for 3 days.
There's some good stories too. Don't despair. There are people out there that care.
There are some really good people out there.
They're
You are completely right. There's amazing people out there, and they would go through great efforts, and they will. But and the reason we do these talks is that if you do a better job at authoring your documents and provide clarity in those documents, it's less opportunity available to them to take advantage of your situation. And unfortunately, folks, if I didn't just show you, what ends up happening is you are the one that has to protect yourself, which is sad. It truly is sad. But if you just sign the blank documents that are out there and you don't understand what you're signing, you won't be protected. So,
I have a question about the slide you presented before this one, the list.
the substitute decision maker?
Yes.
All right.
So if I have a power of attorney document
For personal care?
for personal care, does the guardian of the person trumps that? Or is
Yes.
that the document?
No, if your capacity is such that the court has ordered someone to be a guardian over you, legal guardian, then that is the trump card. That is not done easily though. So if we've referred you to the public guardian and trustee, for example, and there's a capacity issue and you're at risk, they may. Like I've referred over 15 people, they've only taken 3 for personal care. Everybody else is property. And the government, the courts do not want to do this because what is it ultimately is your civil liberties. Because personal care is everything about you as an individual, and now that is given to someone else to manage.
So my
and
attorney
decide.
it doesn't matter. It doesn't matter if I already have a power of attorney with an attorney.
Yeah, so that if you have a power of attorney, right there,
Yeah.
unless something were to happen to you, hopefully nothing ever does, but if something were to ever happen to you, such that we would have to seek guardianship.
Okay.
But most likely, this document will cover you off, as it does in most cases, okay? But that's just as high as you can get on the list, for lack of a better way of putting it. But you will hear in the medical world all the time, who's your SDM? Who's your substitute decision maker is what they're asking. That's what they're referring to. It's out of the Healthcare Consent Act. Yes, sir.
A power of attorney, is it better to have 1, 2, 3 people?
That's part 2, but yes. Let me answer that question by asking you a question. Anybody got 3 kids? All right. Moms, did you ever ask your 3 kids what they want for lunch and get a consensus? No. No. So I want you to imagine for a second that you're in a hospital situation and you've appointed your 3 kids as your attorney. They now must work as one, right? All 3 must work together. And you're asking them to make a decision on your health care. This probably turns into a vote or democracy rules. And I've actually heard it from some cases, while the 2 of us decide it. No, the rule is all 3. You're not the one, you don't want to be caught in the middle of a vote and ask for a recount. This isn't the time, it's not appropriate. So I caution you on 3. Do not do 5. I've actually seen 5. Yeah. Yeah, there you go. Exactly. But then they get in an argument. It's who's the rock, who's the paper, and who's the scissors, right? The other thing that's very important when you use multiple people is you will see the word "and." When you may also see behind that saying jointly or severally. If you appoint more than one person, do not put severally, because you just said they can work independent. You defeated the purpose of appointing. Same for an executor or executor X. Same for power attorney appointing an attorney. You want the word "and." And you don't need to, but if you are doing it and you want to make it a little more legal, must work jointly.
The scenario that you came up with the 3 children, all 3 of them are on the power of attorney.
Right.
However, it does say any 2 of the 3.
Yeah, but see, now you're getting in a voting issue. So, and again, as a parent, you would probably know better than I would ever, but sometimes 2 of them get along really well and they gang up on the 3rd. Other times, these 2 are the ones that get along and they're ganging up on this. Sometimes they're all independent adult kids, you know, and what you're doing is you're bringing democracy into your life. Now, democracy is a beautiful thing, just not necessarily appropriate at the time. And the other problem is that what could be happening is if you pick 2 of 3, when it comes to property management, what that says is they need 2 signatures. So if, and I'm not saying it's going to happen, you are completely right. There's a lot of nice family out there. I do not want to distract from that. I unfortunately don't see a lot of nice family, but there is a lot of nice family out there. So let's say that A and B, you picked A, B, C, okay? If I had a board, I hope you follow me. But A and B are my power of attorney, continuing power of attorney for ops. So they go into one financial institution and they conduct a transaction. These 2 sign. C knows nothing about it. Now A's the questionable one. So he grabs C one day and he goes into a different financial institution. And B knows nothing about it. You see what's going on? But what people don't realize is that A, B, and C are completely accountable for all of it. So I can charge A, B, and C, whether B stands there and says, I didn't know anything about it or not, because they're required by law to know about it. They must know about it, but you've permitted it to occur without that happening. So again, be cautious of 3. What happens with 1, oh boy, I'm sorry, it's going to take me 5 minutes. What happens with 1, folks, is that there's a couple big things. First and most importantly is the potential of dangling the carrot. Even more so dangerous if you pick the person power attorney for a continued power of attorney property, you've appointed the attorney, and it now becomes your executor or executor acts. So I manage the property over here, and I'm also the one that manages it later. Could I be the one to cook the books? I'm not saying that they would, but the carrot is out there. There's no check and balance in place. So I can do this. Well, who's going to know about it? Oh, me, the executor. Okay, cool. I'm in the money. Wrong time to be singing that song, right? This is your life and your estate. So when you have that one, you set yourself up, the dangling of the carrot. 86%. I don't know about you, but I wouldn't want to be in that factor. The other component is that you put all the pressure on one individual. What you're asking someone to do is make decisions about your life, whether it be personal care or the management of property. But they're mirroring the same type of decisions in their personal life at the same time. They're raising their children, probably much younger. Normally, they're younger children because you picked one of your children. So they're going through everything that you went through in life. They're balancing bills, work, sports, hockey moms, all that other stuff. And now you're asking them to make all the decisions for you. So make appointments, order X, Y, Z, arrange visits for the hospital, arrange visits to your home, arrange cleaning of your home, the lawn care. So everything they do here, they're also doing here. And I've actually seen it where one particular lady who was living a distance from their parents was in this state and would drive an hour and a half and would go Monday, Tuesday, Wednesdays, live with the parents. Thursday, Friday, Saturday, and Sunday was with their own family. Then back and forth. That's called caregiver burnout. And you're going to burn them out really, really quickly. They may end up start making decisions that aren't appropriate because they're doing B is convenient, or C, I think in doing the best I can, leave me alone kind of deal. So you put a lot of stress on them, living your life, living their life, and hoping that they're going to make decisions for you. If you pick a two, they can share it together. They have the opportunity to share. And they also have someone to turn to. It's not like, this is not what I like the dad's going to say. Hope you don't mind me picking on you for a sec. But this is not what I want to happen. But this is what Dad told us to do. This is what we need to do together because this is in the interest of Dad. And it helps give that strength, right? Now, if you take those two and make your executor, again, you're going to have a better chance, unless they gang up today, then there's no guarantees in life, right? But again, if they're supporting you while you're here and becoming afterwards, cool. Now, what I often tell people, and it's going to get complicated for a second, I go back to A, B, C. Point A, B. If you, for some reason, A is no longer available, then appoint B, C. Or for some reason, B is not available, A, C. So you always want two. So always have an alternate, but don't make it such that it goes back to one person, because you want that checks and balance, if that makes sense to you. And in that, always remember, your document's still good unless you lose all three people. What's the chances there? Limited, right? So even if, God forbid, you would lose two of them, it's still valid. So you're good to go in that sense. But you're always, again, I will not advise you, but I would suggest you want more than one. Be careful getting into the democracy issue. You're not a ballot box.
We only have 2 kids, but I am one of 3, and my mom now has diminished capacity, so that will is not being changed. And there's 3 of us. So we're going to be voting. I think we're all going to agree.
Yeah.
I'm hopeful.
And a lot of families that occurs. But I've actually also seen it, going back to cases, where the sister and brother ganged up. The one brother was the one that looked after Dad, did everything for Dad. These two got together, stole his cottage, and then got him in such a financial mess that when he died, this brother stepped out of it, and then it just turned into just an ungodly mess. And that poor man, I met him, thank goodness he had no idea what was happening to him. Yeah, but it destroyed the older son.
Yeah.
Destroyed him. Oh yeah, unfortunately. I thank you for your time. I hope you found that of value.
Thank you.